As some of you know, I'm Charlie Pillsbury. I'm co-director of the Center on Dispute Resolution here at Quinnipiac Law School. And Carrie Cass, who I think will be here, is my co-director. And we are also grateful to our dean, Jennifer Brown, for starting this speaker series with Yale Law School. Unfortunately, my colleague at the Yale Law School, Noah Messing, who organizes the speaker series with me, well, not unfortunately for him, but for us, he's in Australia on sabbatical. So he was not able to make it today, but we are delighted that our speaker made it up from New York City. Edna Sussman is a distinguished alternative dispute resolution practitioner in residence at Fordham University School of Law. And she is distinguished, exclamation point. She's a full-time arbitrator and mediator and serves on many arbitration and mediation panels, including, and I'm not listing them all, the American Arbitration Association, the International Institute for Conflict Prevention and Resolution, FINRA, Financial Industry Regulatory Authority, the U.S. Institute for Environmental Conflict Resolution, and centers in Hong Kong, South China, Shanghai, Singapore, Korea, Kuala Lumpur, Switzerland, Vienna, Dubai, Kigali, and British Columbia. I guess to name a few. She also serves on the mediation panels of the federal, state, and bankruptcy courts in New York, and has successfully handled numerous complex disputes, both domestic and international, in many commercial settings. Ms. Sussman serves on the board and executive committee of the AAA, and that's the American Arbitration Association in our field, and on the board and as vice president of the College of Commercial Arbitrators. She was named as one of the 10 outstanding international mediators by Who's Who Legal in 2013, and selected based on peer review as Best Lawyers, the 2012 New York City Mediation Lawyer of the Year. And last but not least, she's a graduate of Barnard College and Columbia Law School. So we welcome the very distinguished Edna Sussman. And I'm going to circulate the sign-up sheet, so check your name, and if you're not there, add it. If you're there, correct the spelling, and add your email. So we have it. And we'll begin with you. It's actually delightful. We actually have, I'll just embarrass him for a minute, but we have Edna's sister here who lives in North Haven, and her brother-in-law. So they've come all the way from North Haven to hear Edna speak. So we're delighted to have this family support.
Thank you. Thank you. Thank you for that very gracious introduction. I hope the talk is distinguished as the introduction makes it out to be. So it's really my pleasure to be here, and a pleasure to be here so I have an opportunity to visit with my sister. So this is really very opportune for me. This came about because Noah Messing, who coordinates this program with Charlie, was in my AAA training class. I do the training for the new arbitrators for the AAA, and there was Noah Messing, and I knew Noah Messing the day he was born because his father was working with my husband at the time. So we go way back, and so it was really kind of a pleasure to do something for Noah, and now for Charlie. So the subject of today is arbitrator decision-making, unconscious influences, as you can see. It is really a hot subject. I first gave a talk on this, I think 4 or 5 years ago, but it had caught on like wildfire in the arbitration and mediation community. You've probably heard a lot about it in the mediation community. There have been so many talks about psychology and negotiation in that context. There hadn't really been as much work done in the arbitration context and the unconscious. So this has become, as I said, a hot subject. So just looking back at the last 2 years, Brunel University had a 2-day program on it in 2013. The ICA Congress, the ICA is the organization, it meets every 2 years. It is sort of the place that all of the international arbitrators convene every 2 years. It is a really big deal conference. And they had their plenary, their first plenary was on arbitration and decision making. The empirical study hasn't come out yet, but it'll be really interesting to see what it demonstrates when it does come out. The International Arbitration Institute's conference coming up in June is going to be subconscious influences in international arbitration. That is the theme for the entire day. And finally, the guy who ran the Brunel University program has now gotten Kluwer to commit to publish a book on the subject. And he has, something like 30 chapters by lots of very prominent people. So this is the subject of the day and is getting increasing attention and hopefully increasing attention by arbitrators as they try to take this to heart. And the purpose of my having put it together and the purpose of the talk really is to make people who serve as arbitrators conscious of these unconscious influences so they can do what can be done to make sure that they really are neutral and as unbiased as a person could possibly be. So what is a judgment bias? So to quote Timothy Becker, psychologist, mental contamination is the process whereby a person has an unwanted judgment, emotion, or behavior because of mental processing that is unconscious or uncontrollable. There was a lot of work that was done by Guthrie, who's now the dean of, I think, Vanderbilt, Ryszlinski, who is a magistrate, and Wistrich, who is at Cornell Law School. And they have done an enormous amount of work with judges and judges' decision-making. And I'll be showing you, and as I saw, some of you have the article, and as I talked about in my article, some of the empirical studies that they did as they met with judges and tried to get under what these unconscious influences are and how they affect decision-making. So the way they described it is we should take steps to limit the impact of blinking on the bench. And that was actually the title of their article, Blinking on the Bench. It's been recognized by judges as well, really all over the world. Lord Goff, one of the prominent UK jurists, said there is also the simple fact that bias is such an insidious thing that even though a person may in good faith believe he was acting impartially, his mind may unconsciously be affected by bias. No surprise, right? But it has been recognized by many, many judges. Judge Frank, the conscientious judge, will, as far as possible, make himself aware of his biases, and by that very self-knowledge, nullify their effect. This was back in 1943, Second Circuit, recognition of the same thing. There's a new book that just came out with actually a preface by Judge Posner called Blindfolds Off, Judges and How They Decide. And I found this one little quote which kind of sums it up by Judge Hellerstein. Justice does not require absolute purity, but it does require a check on bias. So the object really of this whole exercise is what can we do to check our bias and what are the biases that we are prone to just because we're people. Just like everybody else, we're people and we have our natural biases and natural unconscious influences. So Justice Scalia, what does he have to say on this subject? While computers function solely on logic, human beings do not. All sorts of extraneous factors, emotions, biases, preferences can intervene, most of which you can do absolutely nothing about, except play upon them if you happen to know what they are. And part of my talk actually is directed not only at arbitrators, but also at counsel, and how they might want to be thinking about some of the unconscious influences and try to do their best to really present their case in a way that's going to work best given the unconscious influences that everybody, arbitrators have. So some of you, I'm sure, have read Kahneman's book, but this is going back to basics. The System 1 and System 2 that Kahneman talks about goes way back. I mean, Plato even talked about it back when. He described it as two horses, this very large, irrational, passionate, undirected kind of part of your brain, and there's this little tiny one. The horses are not exactly the right size. The brown horse should be much bigger as compared to the other horse. I don't like to get into the real biological part, but some people show pictures of the brain, and the part that is just intuitive and just acts is huge, and the part that actually does the thinking is really tiny by comparison. So Plato talked about that and said, the big horse is very dominant. Descartes talked about it, intuition versus deduction. And Kahneman, many of you may have seen his best-selling book where he describes it as System 1 and System 2. It's been firmly established in all of the psych literature and the empirical studies that have been done on psychology that it's true. You've got this bit, and you need it. You can't function without System 1 that just makes if you had to think about everything you did, you would be paralyzed, right? So that part of the brain is crucial. You really need both parts of the brain. So I'm not trying to diminish the role of System 1. You really couldn't operate without it. But the object here is to not let System 1 take over on everything and let System 2 come in a little bit more when it should so you can really use your deliberative functions to make an appropriate conclusion. So I like to call it blinders, which I picked up from the three gentlemen that did the studies that I talked about before, because bias is really such a loaded word in the arbitration context. You know, bias suggests a lack of neutrality, a lack of impartiality. So I've adopted their phraseology and calling them blinders. So they pegged it as three different kinds of blinders. Informational, basically unbiting the apple of knowledge. You know, once you've already heard something, it's there, right? We'll talk about that. Attitudinal, it's just who we are, our backgrounds, what we bring to the table. It's going to influence how we think and react to things. And cognitive, you know, this is very much the system one thing, the heuristics, mental shortcuts. Your brain just goes right to whatever it is you should be doing or should be thinking. And so those are the mental shortcuts, which we will also be discussing. So, as I said, they did experiments, 265 state and federal judges at a series of conferences, quite experienced, an average of 9 years on the bench. It's a program called Psychology of Judging, and they conducted it on an anonymous basis. So hopefully people were responding as accurately as they could. I actually ran a little survey and got 400 respondents, which I gather is a pretty good number. And to the extent that some of it is relevant to this particular conversation, I have put them into the slides as well. My respondents were 80% from the US, the rest from jurisdictions around the world. Pretty experienced group also. 55% had served in over 50 cases, and 20% in between 20 and 50 cases. So it was a pretty experienced group that responded to these questions. So informational blinder. This is one of the experiments that they conducted. There was a privileged communication. Half the judges looked at it. It was a document that was incredibly detrimental to the claimant's case. It basically gave his case away. So half the judges actually were shown the document and ruled that, let's see, 75% of those judges ruled that the communication was privileged. Half of the judges didn't see it, all right? So you've got 75% of the judges who look at it and say, it's privileged. I should not be considering this at all, right? The control group, the other half, don't see the document. So what do you think the result was? Do you think there was a difference in the result between those two? Yes. Judges who didn't see it, 55% found for the plaintiff. Judges who saw it, 29% found for the plaintiff. They couldn't take that document that killed the case that was privileged, that they shouldn't have seen or certainly shouldn't have regarded at all. They couldn't get it out of their heads. So that was, I thought, a pretty compelling one. Subsequent remedial measure. As we all know, under the federal rules at least, you're not supposed to consider those. That's not good evidence of what a prior act should not have been. So it was an experiment with a gasoline flare-up, flame from a gasoline can with a bad burn. The company said, almost never happens. Nothing we should have done about that. Subsequently, they sent out a warning and a recall letter saying, gee, this could be a problem. There could be a flashback. It was held inadmissible as a subsequent remedial measure. So judges who saw the evidence, 75% not liable. Judges who did not see the evidence, 100% said not liable. You know, again, could not get that out of their heads, even though it technically was not admissible, should not have been probative of anything. Who knows why subsequently they actually decided to do the callback. May not have been related to what happened then, but couldn't get it out of their heads. So, question that I put to people, and those of you that arbitrate will not be surprised, but the question I put was, do you exclude evidence that is not admissible under the evidentiary standards you believe would be appropriate outside the arbitration forum, rather than take the evidence and give it such weight as you deem appropriate? How many of you heard the arbitrator say, I'll take it for what it's worth. I'll give it as much weight as I think is appropriate, right? Well, not surprisingly, only 1% said they never take it. So 33% said never, which means they always take that evidence because it's safer, right? Arbitrators are afraid that they'll be vacated for failing to take evidence. That is one of the grounds on the Federal Arbitration Act for being vacated, so they're very careful about not taking evidence. So 33% actually said never. We always take everything because it's safer. 55% sometimes, and only 1% said never. All right, so all that evidence that we just saw that wasn't admissible, it's coming in. And it's going to affect what you're thinking? Yeah, probably. So we can talk about, and when we have a Q&A, you can give me more ideas. How do we control that? How do we manage that intuitive subconscious reaction that we have to things that we hear? So what is the application to arbitration? Hearsay? Do we take hearsay? We take hearsay all the time. And, we say, well, it's not important for us. The juries, they need it. They don't understand. It came from, we have all those evidentiary rules in court because the juries are not as well schooled in the law and can't make these distinctions. So really, it's okay for us, right? Is it really? All right, so we take hearsay. Expert witnesses, I find the same thing. We don't really do the Daubert thing, so we pretty much will let almost any expert testify about almost anything. We will give it as much weight as we think is appropriate. How often do we actually say he's not qualified and we won't let him testify, or her? Not hardly ever. And then I find that even more egregiously, often the expert will wander into areas as to which they are really not qualified. And do you cut them off? Probably not. All right, so you're hearing all this expert witness testimony that really ought not to be probative because they're either not qualified or they're just, going way beyond their narrow qualifications. Privileged document review, that was one of the experiments we saw. Now, sometimes you are asked to look at documents that are privileged. There's a claim of privilege, and like a judge, you're asked to review it in camera and make a determination. So A, think about this, and B, if the other side does ask you to get somebody else to look at them, I would just suggest you think about it. Gee, is it going to slow down the process? Who's going to pay? How do you do it mechanically? There are issues to think about, but there's certainly the International Bar Association rules for the taking of evidence give you the authority to get somebody else to come in and do that review. And I would just suggest that if it comes up in one of your cases, think about it before you just reject it and say, too complicated, too expensive, too much of a delay. Sometimes it might be the right thing to do for these reasons. If the party feels very strongly about it, it's something to think about. Sometimes you hear about unrelated criminal or other bad conduct, that people sneak in there to get the sympathy going the other way. Should you let it in? We were talking before, we let almost everything. This maybe we would draw the line. We might not let it in, but think about the impact it might have. So what's the answer? Are we less generous in admitting inadmissible evidence? Probably not, because we're all scared of that vacatur thing. Our most important job is to deliver an award that is enforceable. So probably not, but we could be more aware of the impact. In terms of counsel, do they want to highlight the inadmissibility of some of the evidence, the unreliability of some of the evidence? Judgment call? Experiments that have been done with jurors, for example, on disregard that evidence or it's stricken from the record, well, that's all they remember. So you have to be real careful about this one. So it's something to think about as counsel, but it's not a knee-jerk. But it's something to think about. So in some cases, a motion in limine might be appropriate, but there is that countervailing, this is what they'll remember issue there. So attitudinal blinders, personal predilections. Studies have shown that Democratic judges are 1.42 times as likely to render a liberal decision. Not surprising, looking at some of our courts. I will not comment further, but one sees political proclivities demonstrating themselves on the bench. There was a study done with in a brokerage case. The broker arbitrators were more likely to rule for the broker than the other arbitrators. They had an affinity to that profession. They thought they understood it better, maybe, but they were more sympathetic, and they did. Other forms of bias, when you get into, well, I was going to say international. I live in New York City, and actually, if you practice in Queens, which I don't, but I was talking to a mediator in Queens, and you know what? She sees every nationality and every kind of cultural difference, so this is really applicable here too. But you do get people from different cultures, different ways of presenting themselves, different mannerisms, all of which one might be biased against or have different reactions to. So that's going to affect your thinking. Race, culture, some of that's very deep-seated and hopefully unconscious for all of us, but maybe it's there. Corporate versus individual, are we feeling more, based on our background, more receptive to the individual or to the corporation? I think there's probably a lot of that going around based on one's background. So prior experience and influences obviously makes a difference. So I did add one slide to this presentation. I found it on the internet the other day. This was an experiment that was done, that was shown for a nanosecond to a group of Americans and a group of Japanese people. And then they were asked what they saw. And the Americans said, I saw some giant fish. And the Japanese said, well, I saw a pond, and there were some fish, and there was some seaweed, and there were some little creatures on the bottom. Completely different take on the same thing. So how does that parlay itself into the way witnesses testify, into the way different arbitrators perceive what's being presented? Think about it, and think about how receptive you need to make yourself as different people present differently, because these cultural differences really do manifest themselves in presentations by witnesses, presentations by lawyers, and in the thinking of the arbitrators, obviously. So, application to arbitration, this is fairly obvious. Our background, personal experiences are going to influence us. Sensitivity to different presentation styles. When I said this plaintiff versus defendant, the underdog, the corporation, fill it in for yourself. Think about it as you're assessing your case. So, what can you do as counsel? Careful selection of arbitrators, obviously. Everybody tries really hard to find the arbitrator that is going to be most sympathetic to their case, that will have the unconscious biases. They're going to be most favorable to them. I gave this talk once, and he said, "You've got to be kidding me with this. We're going to spend all this time and money finding the right arbitrator, and then you want them to be de-biased? Really?" So kind of a funny remark and kind of true to life. More expansive arbitrator interviews, maybe. Right now they are very constrained, and perhaps appropriately so, to sort of diffuse any possibility of ethical violations, any biasing of the arbitrator by talking about the merits of the case in advance. So I'm not talking about the merits, but is there more we could do that doesn't encroach on the merits of the case in terms of the interview of the arbitrator to get a better sense of some of these underlying unconscious factors that you wouldn't read about in their online bio? Or maybe more about their procedural practices. What do they mean when they say they give it as much weight as it's entitled to? It might make that arbitrator think about it a little harder when he's actually judging your case, if you've brought that up. And maybe they really will think harder about the weight to be given to it. So that's something that I'm thinking about. It would be a little dangerous to change the really sort of narrow strictures of the interviews that are now permitted, but I don't know. This may be coming. Mock arbitrations, I think, are getting more common. Using the expertise of the social scientists, which, as you know, are used a lot for the jury cases in terms of determining what kind of jury pool you want, how you should present your case to the jury. I'm finding there's more of that being done now in arbitration. Actually, the American Arbitration Association just started a program this month, I think, with Decision Quest, which is one of the largest jury consulting firms and trial preparation firms, to have sort of a quick and dirty mock arbitration. So for a fairly limited amount of money, you can get either 3 or 5 arbitrators to look at your case for a very limited period of time and give your reactions. So, there's that. I've done 2 which were more elaborate, where they really presented, and I think counsel find it very helpful, both in terms of figuring out how to present the case to suit those particular arbitrators, and if you're really smart, you can get those social scientists involved while you're doing that selection process. It's not for every case. It's got to be big enough to warrant that kind of expenditure. There was one I did, though. It was, I guess it was some kind of structured financial product, which had, I will say, a really horrible name. I mean, if you just heard the name, they were guilty. And I guess they expected many, many, many of these FINRA claims. So they actually collected 40 arbitrators from all over the country and paid all of us, a couple of $1,000s for the day. And they actually used it not only to assess which way the case would come out, so they could assess how to settle it or not to settle it or what, but they also used it as a beauty contest. And they had a couple of different law firms presenting in the different rooms. We were in groups of 5, and they used it actually also to select their counsel. But that must have cost them, I would guess, $300,000-$400,000 to have that whole thing arranged, to get all those arbitrators to do the whole thing. But they obviously expected enormous liability exposure. And so to them, it was worth it. That was much bigger than anything else I've seen. But I think we'll be seeing more of it. I brought it up at a meeting with just a couple of people the other day, and 2 of them had actually done it in 2 of their cases. So it's also kind of a fun thing to do. You don't have to write the award at the end. You just got to see the case and give them your impressions, give them your advice. It's kind of a fun thing. All right, obviously for counsel, you tailor your presentation to be something that is going to be sympathetic, empathetic, attractive to the arbitrators that you are presenting to, and playing to cultural norms. No surprise. Okay, cognitive binders. So this is a different category. Before we were talking about informational binders. Now we're talking about cognitive binders. Hindsight bias. This is another experiment those three gentlemen did. Was a failure to take precautions against flooding negligent. Find yes if at the time you would have found more than a 10% likelihood of a flood. Half the judges were told that no precaution was taken and the flood costing $1 million occurred. What do you think? You can guess, right? Those who were not told about the flood, 24% found negligence and they should have taken precautions. Those who were told about the flood, 57% found negligence and should have taken precautions. So what does that mean? That means that they couldn't separate what happened later from what should have been known at the time. Think about the Madoff cases, for example. And there are lots of those. Were there really red flags? Should people have really figured out that the man was a fraud, that his whole operation was a fraud? Interesting question. I had one case, it didn't go to, well, I guess it did go to hearing. It was on diversity. It wasn't on the red flags issue. But the documentation this organization put out was amazing. I mean, these people got statements every time there was a transaction. They got monthly statements every month. Maybe not so obvious. Maybe yes, maybe no. I never heard that case. But hindsight bias, big time, right? All right, another one, anchoring heuristic. These were the mental shortcuts I mentioned, heuristics. This is the system one stuff. Auto accident, arm amputated, facts presented. Some judges heard a demand of $10 million in a settlement conference. Other judges just heard a demand for a lot of money. Did that make a difference? Yes. Judges who heard $10 million awarded a mean of $2.2 million. Judges who only heard a big number did $808,000. Right? Totally irrelevant. That anchoring was totally irrelevant. And people do a lot of experiments with. I'm not going to do it. Telephone. Think of your telephone number and then tell me, how many degrees it is outside. You'd be surprised. I mean, totally irrelevant anchors will influence the number you come up with, and it's been done in a million different contexts. So, which do you find? So, we say, well, we're arbitrators. We get all this information. We're doing a really careful analysis of the damages. This really doesn't affect us. Think about it. Does it really not affect you? In terms of, I guess one of the questions I asked was, which do you find more difficult to decide? Liability or quantum of damages, the amount of damages? So what do we get? We got 43% said damages were more difficult, and only, 18% said liability. So this is a tricky area. Recently, I guess it was the Yukos case. There was it was a big number that was asked for. It was $125 billion. The arbitrators awarded 50. Still a big number. The respondent in that case decided not to put in any evidence of damages themselves. That sometimes the respondent comes in and says, that's the wrong number. If you find liability, there's no liability, there's no liability. But if you find liability, here's the number. They decided not to do that. All they did was attack the damages claim that had been made by the claimant. A lot of people have wondered about whether that was a good strategic decision. So, that's sort of a comment and I've spoken to a bunch of people about it, including people who do a lot of expert work as damages experts. And I really wonder, and sitting as an arbitrator, we can talk about this later, but you need a number to hang your hat on, right? So if you don't like the claimant's number and nobody's given you anything else to work with, what are you going to do? You have to have a basis for the decision. So I would just suggest that it might be useful to think about both the anchoring issue and the fact that you're not giving the arbitrator anything to work with if they want to do a lower number because their number doesn't sound right. All right, framing. I mean, this is sort of the heart of being a litigator and presenting a case. So one experiment. Alan was described as being intelligent, industrious, impulsive, critical, stubborn, envious. Ben was described as being envious, stubborn, critical, impulsive, industrious, intelligent. So who do you think people thought was a better person and more likable? Alan, hands down, right? Same words, just different order of words. All right, there was a film. How fast was the car going? It was between 30 and 40 miles an hour. So they just used different words. Smashed, 40 miles per hour. Collided, 39 miles an hour. Bumped, 38 miles an hour. Hit, 34. Contacted, 31. Obviously, right? But choose your words with care. How you frame your case is going to make all the difference. Cognitive bias. I thought this was one of the best experiments. Confirmation bias. All right, this was done during the Kerry-Bush elections in 2004, and they actually had people, hooked up with electrodes that could measure what was going on in their brain. And remember, I talked about the really big part that's sort of intuitive, and the little teeny part that actually is paying attention and trying to think about what's being said. So they showed things that were either pro-Bush or pro-Kerry. Well, whichever side they're on, nothing went into the thinking part of the brain. Zero, just passed right by. So people only hear what confirms what they already believe. It's been demonstrated a million different ways. So that obviously has enormous implications for what we do. So one of the questions I put to my little group of 400 responders, which I did through SurveyMonkey, right? Like everybody. All right. In what percentage of your cases have you changed your mind and rendered an award that is at variance with your preliminary pre-hearing view if formed? We skipped one here. Oh, well. All right. So only, oh, shoot, I thought I had this here. Only 8% actually changed their minds after from their preliminary view, which is not very much. I'm reminded I've given this presentation. Actually, it's been a very popular presentation, but I was giving this presentation in Salzburg last spring. And the German arbitrators and the Swiss Germans really think that it's part of their job as arbitrators to give preliminary views. Usually after they've gotten the submissions, at the beginning of the hearing, they ask if the parties want it, but it's the way their judges work. So they really expect that, and that's their job. And so they give their preliminary views. So I'm talking about how, well, once you form a preliminary view, it's very hard to shake it. So this German guy raises his hand, very nice man. He says, well, I was on a panel once, we changed our minds once. And so I thought, all right, perfect. Demonstrating my point from the audience. So it's hard, hindsight bias. I mean, our job always really often is to reconstruct what happened in the past, what must have happened. It makes the actual outcome seem so much more predictable, right? So that's a problem. Anchoring bias we discussed, assessing damages. The anchor can really impact our thinking, so think about it. Framing, this is always, you have a really good lawyer on one side and perhaps not so good on the other side. He's not framing it so well. So trying not to be overly swayed by the person who's doing a great job of framing, whereas the other person may have a better case but isn't framing it as well. Confirmation bias, we have to listen and keep an open mind. An early view can really affect our thinking, and we just hear what confirms. If you start forming that impression, a lot of evidence comes in, and a lot of it can cut both ways. And if you're just sort of screening out the stuff that cuts against what you have initially decided is probably the right story, and it's subconscious, so to think about. Okay, so application to counsel, hindsight bias, emphasize what was known then. Maybe you do a timeline, whatever. If this is really important in your case, really try to establish which facts were known then and do it subtly so it gets out there, but you're not hitting the arbitrator over the head. Anchoring, we discussed, thinking about it. I guess the flip side is, when you're talking about anchoring, as a claimant, do you want to make it really high because it's going to anchor high and they'll just drop off? Respondent really low, so you come off that. Obviously, it has to be credible. Credibility is the most important thing. But within a range of credibility, experts can come up with all kinds of numbers, as we all know, and different factors can be brought into that analysis to change the result. Framing, think about carefully. Confirmation, lawyers, strong theme, story from the start, right? You want to get that story across from the beginning. Thank you. All right, egocentricity. Judges were asked to estimate their reversal rate on appeal. What quartile would they fall into, right? Compared to other judges. Top quartile being the one with the highest reversal rate. 56% put themselves in the lowest quartile, 31% in the second lowest, 87% thought they were better than half of their peers. No surprise. We would probably all do the same thing, right? Okay, so Judge Posner, the psychology of judges includes the belief that one is almost always, some judges think always, right. All right, so on a scale of 1 to 10, how sure are you that you have reached the correct result by the time you render your award? 27% said 10. I am absolutely certain. 52% were at 9, so pretty close to absolutely certain. 16.3 were at 8, and you can see almost nobody. But I would say this is actually a good result, because if you're not that sure, you shouldn't be issuing that award yet. You should be thinking about it some more until you get to that level of certainty. But are you really certain for good reasons? People, I mean, this is another psychological kind of thing. People hate being in a state of doubt and will do whatever is necessary to improve from doubt to belief. Judge Posner is obviously very interested in this area because I'm quoting him a lot because he's written about it a fair amount. The language of judicial decision is mainly the language of logic, which flatters that longing for certainty and repose, which is in every human mind. Justice Holmes, way back in 1897, judges want to get to that point where they are comfortable and sure. Hutchinson, who was actually undergoing Freudian analysis at the time, talked about the hunch, that sudden feeling of, we got it. It's not every case where you have that feeling, but often, all of a sudden, it comes together, that hunch comes together, you have that moment where you're there. Coherence bias, it's the feeling of pleasure reward triggered by the feeling of being certain. And this is another brain thing. It's actually the brain's mesolimbic dopamine system. It's the same biology as, sex, drugs, and alcohol. It just makes you feel good, right? You feel good. You've gotten there. So are we getting there too soon? Are we getting there because we are impelled to get there because that's the way our brain works? So how do you overcome it? Overconfidence, obviously, can lead to poor decisions. So think carefully. Being aware of the mental contaminant, being motivated to correct it, trying to get control over it. But even if we believe we are biased, people don't believe that bias has infected their judgment. The bias blind spot is what they talk about. So I think we all recognize that we have unconscious influences that are operating on us. We probably think, but it's not affecting our judgments in the cases that we hear because we are really careful and we think really hard. So the psychologists have concluded that awareness, knowledge, and motivation don't work. Control does not follow. There's a sort of a denial, the illusion of objectivity. Another anecdote, I gave this talk, as I said, a couple of years ago, to a very great group of the New York State Bar Association dispute resolution section. And I was talking to one of the leaders of the organization at the end, and I said, what do you think? And he said, well, we're arbitrators, we're not judges. This is all irrelevant. So I thought, okay, illusion of objectivity, big time. Okay, one of this is Waits and Lawrence are actually also social scientists that have done a lot of jury work and a lot of the kind of work I mentioned earlier. So they have written on this specifically, and they said, a typical arbitrator concludes the initial phase with a single dominant story in mind. Sizable percentage of arbitrators have established a clear leaning by the end of the opening statement. That's really early in the case, right? You've seen the pre-hearing submissions, you've heard the opening statement, you've heard no testimony, and you probably haven't seen very many of the exhibits, if any. So if we form a view early, does it lead to a biased assimilation of new evidence? Is confirmation bias really happening? So decision framework 1, you form a story of what happened, you filter through the evidence to find support. Do we find ourselves, we're kind of sympathetic to one side, and somehow we're kind of finding those pieces of evidence that support that story, that support that part of the case? Compare the story to the allegations, try to make them fit together, negotiate with the other arbitrators. A different way of approaching it. The shift from conflict to closure progresses as the arbitration advances. Try in your mind, instead of building on the one story you think is the right story, really try to build on both stories at the same time. Go back and forth. Marshal the evidence and weigh it from both perspectives all the way through. Eventually something will have to win out, right? You have to make a decision in the end. But do try really hard to try to look at it from both perspectives until the end and really review the evidence each day and see what has transpired that really makes each side sound credible. I've sort of suggested, if you're sitting with 3 people, as you're discussing the case and with the right even party appointed if they're cooperative, and many will be, try to assign and switch off so nobody gets wedded to one perspective, but have them each day, at lunch. What did you hear that supports this side? What did you hear that supports that side? And kind of forces it to happen because it's kind of hard to do it on your own. But if you have 3 people, you might really be able to more easily accomplish that. So which of the following practices do you believe is better? Do you want to confer throughout the proceeding or wait till the end? Occasionally you run into the arbitrators and say, oh, we have to wait till all the evidence is in, kind of like the juries, right? We can't talk until it's over. So my survey showed that 63% share views, 26% want to wait to the end, and 9% weren't sure, kind of depended on the situation. So you can see, the great majority do talk about it throughout. I see people shaking their heads both ways. It's an individual preference. But there it is for you to think about. When you deliberate as a panel, how often do you review the evidence in favor of what you have preliminarily assessed to be the losing side? So only 31% said they always review that evidence to see what the person who lost, what did they have going for them? That's not, I don't think, a very high percentage for really reviewing the case at the end and making sure you got it right. 46% were doing it 50% or less of the time. So mostly people are not actually going over it to see, gee, maybe the losing party should have won, and really thinking about rethinking all of the evidence. So what can you do to debias your blind spots? So just to run through them, I got time. So play both stories through the proceeding, as I was saying before. Consider the opposite all the time, right through to the end. You know, sometimes that piece of evidence comes in at the end, and if you're not watching for it and listening for it, could pass you right by. So marshal, constantly marshal the positive and the negative. Make sure you ask the questions to elicit the story. You know, people have different perspectives on how active the arbitrator should be on asking questions, and so I'm not suggesting you change your style, but you want to make sure you can get to the right result. So I leave it to you, but some questions are usually worth asking, but don't just ask questions that are going to confirm your view. That's not the objective here. Review the evidence that goes the other way. Think about why you may be wrong. Reduce reliance on memory. Right? Memory can often deceive. You may be remembering things the way your brain wants you to remember them because that's the story you thought worked. So go back, check that document, check that piece of testimony and see if it really says what you think it said. Replay how you reached your conclusions. What did you reject? Write down your reasoning. I don't know how many of you do beer awards these days. I guess some jurisdictions, FINRA, I guess there are always beer awards. But write it down, even if you're just doing an outline, just to make sure it really hangs together and makes sense. So at least do an outline of your reasoning. Estimate your odds of being wrong. Were you influenced by any biases, heuristics, inadmissible evidence? Just go back and think about it. Consult your co-arbitrators. Make sure you leave enough time. Sleep on it. Delay decision making. What would you have needed presented to go the other way? What would the losing party think you overlooked? If someone were writing it the other way, where and how would they differ? A lot of us do a lot of this anyway, but I thought just having a list and kind of thinking about it would be helpful. Checklists can be useful, the columns, like, what are the elements of the claim, what evidence came in to support what, and sort of see where you come out. All right, and don't take too many cases so you have enough time to do all this, right? Very important. So, always two ways of looking at everything, right? So this one's easy. What do you see? You see an urn or two faces? Both, right? You see them. It's easy. Now try this one. You see the young girl, the old hag, or the wife or the mother-in-law? Who do you see? So raise your hand. Who sees the young girl? Who sees the old lady? See, most people are seeing the young girl. All right, well, I guess I have time. I can show you. All right, so here's, oh, I forgot. I'm mic'd. All right, so here's the young girl, right? This is her nose, her chin. This is her throat. She has a little necklace on. And if you look at the old lady, right, here's her nose. This is her mouth. And this is a really old hag, right? So sometimes it's harder to see both sides, which is the point of this particular exercise. Sometimes it's easy, sometimes it's hard. Sometimes you have to try real hard, but that's our job, right? You got to try real hard. So just quickly, Gestalt theory of closure, your mind will fill in the gaps. So as you're filling in those gaps, think about how you're filling them in, why you're filling them in the way you are. And finally, Woody Allen's story. When I was kidnapped, my parents snapped into action. So what do you think happened? Next line, they rented out my room. That's not the way you would have finished it, is it? So, all right, well, that's the end of the talk. So, really, it's just, the psych literature suggests that you really can't get rid of your biases, and even if you want to get rid of them, you really can't. So all we can do is try our best, and I think it is our job to do our best. And they're continuing to try to work on better techniques for really figuring out how to increase that deliberative overlay, is what I like to call it, the deliberative overlay in the decision making. So I'm opening it up to questions, comments, reactions from the floor. Yes. They're doing this as a video, so if you could make your comments brief, I will repeat it so that it can go on the video.
what is the role of post-hearing briefs and reply briefs in your scenarios?
You know, it depends on the case. If it's a case that, if you need it, always get it, right? If it's a case where you really have gotten all of the information that you needed from them, you know, I think lawyers, given their preference, often would like to be done, right? They'd like to do a little closing argument at the end of the hearing. Hardly ever happens, I will grant you, in the bigger cases. But, you know, they want to be finished, and it's your job now. You know, we've done our job, we've presented our case. On the other hand, if either of the lawyers wants it, and many do, I will certainly let them put it in. Often there are things that I think I need more information about in terms of the law, and so I need to give them that, you know, what do I need you to do? What facts do I need you to pull together for me? None of this precludes that. You know, I think that could just assist you more in terms of really seeing both sides. Maybe there are things that you missed, and all of a sudden those post-hearing submissions are going to bring it to light for you. So depends on the case. You know, sometimes you don't want them to spend that much more money. Briefing it again, going through the record. Sometimes there's no transcript, which makes it more difficult for them. So there's no right and wrong. It depends on the case, what the lawyers want, what the parties want, how big the case is, whether it merits that kind of expense, and what you need. If you need it, you got it, right? Otherwise, you can't make a decision. Yeah?
I find one of the elements of being appointed as an arbitrator is the difficulty of communication between counsel and potential arbitrators. What steps could the industry, all of us, take to improve that in a way without simply asking, how are you going to decide this case?
You know, the people that are really careful, I mean, it's really very simple. It's, you know, it's just, are you available? Do you have any conflicts? Here are the parties. Broad strokes, nature of the case. You know, it's a contract case involving the sale of widgets. Not much beyond that, really, is in my experience. So that's very safe. On the other hand, I guess they asked me to come in and interviewed me, and it was an hour interview, and I thought, this is really crazy. And I thought, they're going to ask me what I read. I mean, I was trying to figure out, what could I say with my last favorite novel? And actually, it was an hour conversation without ever talking about the merits and without ever asking me about what I had read. I can't even tell you what it was about. But it didn't encroach. I think as an arbitrator, if you feel that they are at all delving into the merits and certainly into what you would do, I mean, you just have to cut off the conversation. You know, the Chartered Institute did guidelines, and they actually suggested that it be tape recorded or you take notes. I think that's over the top. I don't think you need to do that. But I would keep those conversations short and to the point. You know, they want to know about your experience in a particular field, that's fine, or what you've written, that's certainly appropriate. Subject matter expertise, or how many arbitrations have you done? How many arbitrations have you done under these rules? I mean, all of that kind of thing is fair game. But anything that really begins to approach the merits is problematic. When you get into more procedural questions, I guess there's a difference of opinion. Somebody, the Whiten case did a study with PricewaterhouseCoopers, I don't know, 2-3 years ago, and asked a lot of these questions. You know, what do you think is okay and what isn't? And a pretty good percentage, maybe 60%, said that it was okay to ask questions like, would you be willing to entertain a dispositive motion? Generally, you know, what is your feeling about dispositive motions? You know, in fairness, somebody asked me that once in an interview, and I didn't respond, but I had written about it. I said, I will send you my article, and you'll know exactly what I think about that. You know, but that gets, you know, that's borderline, and it depends who you talk to as to whether that's okay or not. It gets borderline. So it's a tricky wicket. It really is, and that's why as I think about, gee, can we do more with those interviews? And some other people have written about it and said, 21st century, that's where we're going. You know, it's delicate. And are you going to be biasing the arbitrator through that interview when you go beyond the basic questions, which is certainly not the purpose, that should not be the purpose of the interview. So it's a delicate area. And, you know, the safest is that really sort of narrow your experience, your availability, and your conflicts check. Short, 5 minutes. And some people have a timeline. I won't talk to you for more than 20 minutes. Jerry Axett was like one of the greatest arbitrators known to man. 20 minutes, that's all he'll do. 20-minute interview, you got it, that's it. So you have to be careful. You know, try to maintain our integrity, you have to be careful. Yeah?
The AAA seems to be moving toward encouraging single arbitrator panels because it's so much less expensive. Our studies show that 3 arbitrator panels are 5 times more expensive as far as arbitrator fees. But this is interesting because this would seem to suggest that maybe the 3 arbitrator panel is a good idea in big cases if bias is a concern. But then, particularly if you have party-appointed arbitrators, you have more of a potential for splitting the baby, which is another rap on arbitration. So, I mean, how do you come out on that?
All right, well, let's back up. First of all, let me start with splitting the baby, because I think that is absolutely not true, and they continue to malign us with that. And certainly the users all think that, and we can't seem to shake them. I actually wrote an article about starting a litigation, starting, I guess, a litigation. I was really young, back in the 80s. And I said, well, one of the things you want to think about is that arbitrators split the baby. Right? Common knowledge, isn't it? So I got a call from the then president of the AAA, Mr. Colson, who wanted to have lunch because he was very upset. And so we had lunch, and he pulled out all these statistics that AAA had, even way back then, in those days in the garment industry, which absolutely did not prove that they split the baby. And they have since done, innumerable studies on it, and it just doesn't. It's a bell-shaped curve, and in the middle there is only like 10 or 20% of the cases where the damages are coming in. The claimant is asking for the moon, and it doesn't make any sense. So there is going to be what looks like a split the baby, but it's really just an analysis of the damages. But 80% of the cases are yes or no, basically. They really, so that's not supported. Although it continues to be said, and anybody who doesn't like arbitration will give you 2 reasons. One is we don't like no appeal, right? You hear that all the time. And because you're going to have the arbitration that goes off the rails and then we're stuck. And 2 is arbitrators split the baby. So we don't, and I don't know how we diffuse that myth. We've all been trying without much success. With respect to 1 versus 3, 1 is really much cheaper and much more efficient. You can schedule things more easily, whether it's the calls or the hearing or whatever. 3 is nice because you have somebody to bounce off. Mr. Guthrie, who I had cited earlier, actually in one of, I think it's called Misjudging, in one of his articles, I always like to pull it out because it makes it sound like arbitration is better than court because you can get 3 people. And so you don't just have 1 person who may be off the reservation or may have a bias, and you've got the 3, which will balance out and come up with a more reasoned and more appropriate response. In terms of the party appointeds, they really are supposed to be neutral. And I find that in my practice, they usually are pretty, they really are quite neutral, not invariably. Sometimes you get the bad apple who doesn't understand the role appropriately. So usually they really are neutral, and it's very helpful. In the situations where they're not, then it's got to be managed. If you're the chair, you manage it. And many people think that it doesn't serve the party appointed well to really advocate for the position that their appointing party has, because the chair will not pay any attention to them after a while because they won't seem like they're being a fair and honest assessment of what's going on. They're just mouthing what's been said. So somebody tells the story about, they were the wing and the other arbitrator was really, really very biased and very obviously so. And the chair just literally, physically kept moving closer and closer to him and further away from this arbitrator that really wasn't assessing the evidence fairly. So 3 is better than 1. If you have a really big case, I guess I would go with 3. On a smaller case, I think 1's fine. I think most arbitrators, you get to pick the arbitrator. So you should pick somebody really good, right? I mean, that's one of the great advantages. You can pick the person who's going to decide your case. So 1 should be fine. I mean, I'd say probably 1/3 of my cases are probably sole arbitrator, and I like to think I'm doing a good job on them. I think we all think we're doing a good job, and we probably are.
Which heuristic is that?
I think that's right. We got a lot of them here.
All of them.
Yeah, exactly. I guess it's the one about those judges, right? The judges, all of them think we're in that top best quartile, absolutely. Yeah. Other questions, comments? Yeah.
In my field, which is labor arbitration, I always see the same practitioners over and over and over again. How do you prevent bias in that situation where you almost know how they're going to present their case?
Yeah. The question was, I forgot to repeat before, the question was, how do you prevent bias when you have the same practitioners appearing before you all the time? Well, I guess I look to you for answers. That doesn't happen in my practice because I have sort of very broad-based commercial practice, so I don't see the same people. And so what do you do?
I I try to stay neutral. It's very, you kind of anticipate what they're going to do, but you have to, I think, knowing their style, kind of just balance the other way just a little bit because you know what's coming already almost.
Yeah, but you do your best in every situation, right? If you have the same practitioners coming, at least you know what to expect, and maybe you can prepare more for it in a way if you know what to expect. Other questions, comments? Yeah, in the back.
I haven't looked at the literature recently, but about 20 years ago there was a good deal of writing on narrative mediation and the role of narrative in storytelling, and how one party would unfold their story and the second party would essentially be colonized by the first telling. So from the advocate's perspective, putting on an independent story about the events seems and would impact the mediator's language. Is there any parallel other than the advocacy lessons there in the arbitration process or for the arbitrators in terms of helping parties promote an independent story to keep your de-biasing what you're hearing?
Yeah, I mean, I guess what you're bringing up maybe is, what are the other factors is, the primacy thing. The first story you hear is the one you hear, and that's why sometimes the other side should go last, because then the last thing also influences what you hear. The first one probably is going to be more influential, and so whatever you can do to make sure that the other side at least has the last voice. I mean, that's why in international you have so many, you have the first, second, third, and fourth. So the one who gets the last word is actually the respondent, as opposed to we have the three. We have the first, second, and the reply. They have the first, second, the reply, and then the rejoinder. Maybe in part really to compensate for that primacy aspect of the psychology of what you hear first is what you absorb the most and begins to be your first impression. So, and that comes up also in terms of argument in the international, who is going to go last to make up for the first. The other side gets to go last, and as opposed to what we're accustomed to often in domestic practice. So there is that. As an advocate, you do your best, right? They've got a great story narrative. You've got to have a great story narrative too. And if you can, try to be the last word if you're on the not being the first word side. Yes?
Would the challenges be the same in, say, arbitration in malpractice cases? There's some more emotion involved and a few other things, and because they're talking about in some states and even here trying to set up that type of a system. At least certain people would like to see that, and I'm just wondering what your thoughts are on that.
Yeah, this is what, do the same issues pertain in malpractice cases as they're trying to bring them into this ADR community? I would think so. I think there are other issues you have to manage there, namely the emotions. And are there situations where you want to just invite them at the end? Somebody was telling me that at the end of a more emotional, more personal kind of arbitration, they turned to the parties and said, is there anything, the lawyers must have gone ballistic, but they turned to the parties and they said, is there anything you want us to know before we adjourn and we have to decide this case? And so it was almost sort of a cathartic mediation style ending to that arbitration. And as I said, the lawyers were probably unhappy. But the arbitrator found it incredibly helpful to have heard those two perspectives from the two principals, whose case this was, after all, whose case had to be decided. So I think in those kinds of situations, one doesn't mediate. You're not going to go have ex parte sessions. But to create more of an opportunity where maybe the lawyer has, he's really confined it, so he's got just the points that he wants to have made, and you don't get that personal story, you don't get the real interests out there, you might want to be a little more flexible. I mean, there's nothing wrong with doing that. You're permitted to call witnesses, in fact, right? And so just open it up at some point. I mean, not every case. I'm not suggesting you always do this, but, it was a story that resonated with me. And in a situation where that kind of dynamic is going on, it could be appropriate.
Yeah, I could see that being a problem in a medical, for example, malpractice case, because the parties are not on equal footing like in a business situation. You may have a very inarticulate plaintiff or injured party that can't express themselves against the doctor or several doctors, and I just think that might not be the best thing to do.
The point was, in a malpractice case, that really may not, and often may not be really the best way to go, because one person may not be very experienced, may not be as verbal as the doctors. And so, yeah, every situation is different, and you really have to think about what's appropriate.
I wonder if there's a danger, given everything we've learned, in letting the last thing that you hear from both parties be emotional, where you're dealing with both their emotions, empathy, sympathy, likability. If one of them's pleasant, the other is angry. Is that? I mean,
Yeah, good question. It's a good question. You know, is it bad to end on an emotional note, given all this talk about the unconscious? You know, the cases I have are all business cases, so I'm not going there. But the question I was asked in a more emotional case, is there anything special? And maybe it's not ever appropriate, I don't know. This one story that I was told, you know, sounded like in some situations it might make sense. You know, everyone is different, right? There are no cookie cutters in this. And arbitration's a little more streamlined, a little easier to do kind of on a formula. Not the decision making, but, you know, you manage the case efficiently, you get the parties to do what they have to do, you listen carefully to the evidence, you prepare for the whole thing, you do everything as best you can to come up with the right result. But at least you kind of know what the menu of things you have to do is. You know, in a mediation, it's like everyone is really different, right? And you're trying to figure out every minute what to do next to be helpful to the parties. So how much of that can you really bring into the arbitration is a question. But, you know, every case is different, even in arbitration too. So you have to use your judgment. Judgment in the end is what counts, right?
Yes. I wonder what, if any, information or studies there might be that talk about any biases that might be created by who's paying you.
What biases might be created by who's paying you? I don't know of any studies. I wouldn't be surprised. You know, at least with a AAA, you don't know who's, you know, if one, you know, on the commercial side, both parties theoretically are paying half. And if one of them isn't, you're not supposed to know which one isn't, although that's changing a little bit recently. You know, in the consumer stuff or maybe the employment stuff, the rules set out who's going to pay you, and that shouldn't prejudice you because it's in the rules. And, you know, it's set up, or maybe it's set up in the contract itself as to who pays for what. Now, passing all of that, I mean, I don't know of any studies. I would hope people would not be influenced by that. You know, there is that whole field of consumer arbitration and all those not-for-profits that are very concerned about what they perceive as being unfairness in consumer arbitration. I will say that's really all about whether or not they can have class actions. It's not about arbitration, but that's another story. Anyway, they talk about the repeat arbitrator. And their big complaint is you have the same arbitrators hearing all of these consumer cases, so they have a vested interest in getting those cases. If they rule against the big company, they're not going to get those cases anymore. So they are voting with their pocketbook and favoring the company all the time. I don't know that that's really been borne out. I mean, the people that have done studies comparing, you know, a lot of work has been done in the consumer debt field, and people that have actually compared what has happened in arbitration with consumer debt, including that terrible organization that's no longer doing consumer debt, compared to court cases and consumer debt, the numbers are about the same. I mean, I guess usually they must owe the money or they don't have the paperwork. But, you know, it's about 98% the consumers lose in arbitration, 98% they lose in court. There's no difference. There's really no difference. In fact, I think they may have done a little bit better in arbitration because maybe the arbitrators have more time to actually look at it than a judge might, who's got an enormous docket to handle. So it comes up in that context. I guess those kinds of studies have been done, but I don't think it's been borne out even in that context. And I would hope that the rest of us are not going to be influenced by who's paying because we have to live with ourselves. All right.
If not,
Good.
thank you.
Thank
very
you.
much.